Hi everybody, welcome to week 6. I bet
Hi, Nicola.
I'm a funny looking Luke, aren't I? He had
Hi,
plastic
Nicola.
surgery over the break. How did you all get on? Are you feeling a bit rested?
Yeah, we have. Thank you.
Yeah, good. Oh, that's good. Obviously, I'm sure that most of you are still working on things that you've got to do for units and assessments and stuff, but maybe it was just a little bit less intense for you than it normally is, which is the main aim of having the break where it is, just to recharge, regather everything together, and then work towards the end of the term. Okay, so just need to get a couple of things in order. Just give me a second and then we'll kick off. Just close that down. So while I'm doing that, how did everyone find the workshop task for this week? What were your thoughts on it? So we're looking at legal reasoning. Is that something that comes naturally to you guys, or did you find that quite difficult to absorb, the IRAC process or the variants of it? You can put it in the chat if you like instead.
Hey Nicola, it's Amy.
Hi,
Um,
Amy.
I found it quite self-explanatory, but in saying that, a few of us in the group also doing statutory interpretation were very much thrown into the deep end and had to very quickly learn IRAC to address one of our first assessment pieces. But it is quite self-explanatory, and yeah, for myself personally, I'm finding it's coming quite naturally, which is good.
Yeah, okay. What we tend to find is that students struggle on either the R aspect of IRAC or the A, so the rule or the application. They don't tend to struggle on both, it's one or the other. And it's something that you have to be very alert and conscious of in your first term, even maybe your second term at uni, but you will get used to using it and it will start to become second nature. So by the time you're in your second year, it will just be natural to you and you won't even really think about doing it. It's really difficult for lawyers to articulate their reasoning process, I think, because it becomes so instinctive to us, but there is actually a process to it that is often not acknowledged. So for example, in a case, when you read a case, the judge may start by talking about the factual background. They might identify the legal issues between the parties. Let's say it's an appeal on a point of law. They might identify the legal issues on appeal, and then they might go into discussing the relevant legal principles before reaching a conclusion about how that affects the appeal. So they've actually done the IRAC process there themselves, but it's not explicitly articulated. So it's, you don't have those indications or headings or even language that recognizes that IRAC is being used. So what I'm trying to say is that it will take some getting used to, but eventually it will become instinctive and you'll be able to recognize it as well as do it quite easily. Okay, just before we kick off, a couple of housekeeping things. So the portfolios have been released and there's a little bit of feedback on each one. So please review the feedback as well as the mark. If you can't, for whatever reason, access your grades, there might be a technical issue, so please let us know, but also contact TASAC because they definitely should be viewable. The other thing is that the problem question, which is worth 40% for this unit, the problem question has now been released. It was released yesterday, and it's due in week 8. So that would be the 10th of September at 5 o'clock. Now that is based on the next 2 weeks' content. So the things that we're going to be covering today and the things that we will be covering next week are all going to inform what you do in that question. We're not going to be teaching you law, but we're teaching you the skills that you need to complete the assessment. Okay, so start working on it now, definitely, but don't be handing your draft in, tomorrow or Friday, because you need to allow yourself time next week as well to look at what we cover next week. Now, do make sure that you're downloading the assessment itself under the assessment tile in Moodle. And don't think that it's the problem question that Luke has posted in the week 6 area. That's just a sample. Okay, it's a sample question from a previous year with a short answer guide. He put that there really to give you guys a little bit of insight into what we're looking for, and help you understand or break down the topic. So please make sure that you identify the actual assessment and download that, and make sure that you download the question, the resources that you have to use to answer the question, and the rubric. So all 3 documents. Okay, any questions about any of those things? No? Okay. All right, so...
Sorry, when will the assessment be given to us?
It's already there. It's in it's under the assessment tile. Yeah, it was released yesterday.
Okay, thank you.
No worries. Okay, so what I'd like to do is have a look at the workshop questions, and it's a little bit ironic because in the study guide we say make sure that you're adopting a logical approach to the question, but I'd actually like to start with question 2 first. So totally a logical way of dealing with it. So let's start with question 2. Now, what we need to do is explain the function and assess the importance of each of the steps in IRAC. So let's just break that down and start with I. So what does I represent?
Issue.
Yes, very good. And if you were to give me a sentence on that to explain what that means, what would it represent?
The issues of the case. Trying to think of another word.
Well, where do we find the issues?
From the client or the assessment, whatever.
Yep. Yep. So let's say that we're looking at the problem question. We would, yeah, Danica, that's right. We'd find the issues in the question. So when you're given a problem question at law school, it's a summary of the facts. I wish that a real trial just had one document, right, with all the facts on it, because that would have made my life a lot easier when I was a lawyer. But it's a summary of the facts. You can generally take them to be uncontested unless you're told otherwise. So those are the established facts. Your job is to identify the issues that arise in relation to the scenario that you've been presented. So when you look at the problem question, when you read the facts, you have to identify what specific area of the law it is. So is it contract law? Is it tort law? Is it company law? Is it criminal law? Then the next thing to do is identify the sub area within that. So let's say that it's contract law. Is it misrepresentation? Or is it breach of contract? Or is it whether or not the parties have even reached an agreement and made a contract? Yeah, so the job is, in that instance, to look at the facts and identify what sub-area of contract law or sub-area of the law that you are required to look at. Now note that, and this is really important, there may be more than one issue in the question. And in fact, the further along that you get in your degree, the more issues will be presented in the question. Okay, so don't just spot an issue, talk about that and think, great, I'm done. Now, when you're identifying the issue, you really need to have a working knowledge of the law to be able to identify it, okay? So let me give you an example. In contract law, there's a very old rule called the postal rule. And the rule works like this. So if you've got a written agreement between the parties and one of them, it comes to the second party to their turn to sign, they sign it and then they pop it in the post. The contract is taken to be formed at the time that it goes into the post box, not the time when it's delivered and received by the other party. Now, given that Australia Post isn't always that reliable, that can be a big window of time, right? There could be 7 days gap there. Now, that might be important for the parties because in that interim period, one of them might have gone and signed a contract with someone else instead. So what I'm trying to say is that you need to know the postal rule to actually be able to spot that in the question, when the question talks about Sam puts the contract into the post box. Does that make sense? You have to actually have a working knowledge. Now, that doesn't mean to say that you need to know the case. You don't need to be like an encyclopedia of law citing it, you know, with every case citation in your brain, but you need to know the broad principles so that you can spot the issues. Okay, and then as a lawyer, if you need to then go and argue about that in court, you know, I know that the issue is the postal rule. I'll actually go and look up that case now. Okay, so you've got to have an overview or a broad understanding of the law to be able to spot what issues arise in the facts that present legal issues. So at this stage, that makes it really difficult for you guys, because if you're in your first term, you haven't studied much law and you don't have a broad understanding of a particular area. So because of that, in the problem question that you will do for week 8, we actually ask you to address particular things when we give you a series of questions to answer. So we kind of help you spot those issues a little bit, okay? But of course, that safety net is taken away the further you go into your degree and the more that you'll be required to spot issues. And so a question further on in your degree might just simply say, advise X as to whether or not he has committed any offences. So not telling you at all what area of the law you should be looking at there, and you've got to go and work that out for yourself. Now, issue spotting is really important, because if you rush through it, as I've already said, you might identify one or two that are well known to you but miss other aspects of the issue. So I'm going to give you another example based on contract law. So let's say that the parties have had oral discussions, so they've had conversations about the terms of the contract, and then they attempt to conclude the contract in writing, but one of them never gets around to executing the agreement. That means that there's no written agreement between them, because you've got to have both parties agreeing to the terms, okay? So that might scream at you, written agreement. I've got to talk about how you conclude a contract via a written agreement. I've got to talk about that, and then I've got to talk about the fact that it hasn't happened here. But what you may have missed in rushing straight into that is that they could have possibly actually concluded the contract orally. There might actually be a matching understanding of the terms between the parties. So they have already agreed orally what the terms are. And that might mean that there's actually an agreement between them, but it's just not in written form. So it's important that you you identify the issues that pop straight out at you, but then give yourself a bit of time, maybe go and reread that area of the law, and then go back to it and see if there are other issues that pop out on that second reading. Okay, so let's now talk about the R. So what does the R stand for?
Rules.
Absolutely, so it stands for rules. Danica says, finding the relevant rules of law and the relevant legal authority that are supporting those rules. Perfect. So it's not just about showing that you understand what the law is or what it requires. It's about providing a suitable authority and support. So what kind of authorities can you use there?
Legislation.
Absolutely. What else?
Case law.
Yeah, absolutely. Good. So primary sources of law, because textbooks and journal articles are not the law. They are someone's explanation of the law, which makes them an opinion about the law. So when we're explaining the law to our client, when we're appearing in court on behalf of a client, when we're writing and negotiating with the other side, we need to use the actual law to support what we're saying. So we need to be using statutes and cases, primary sources of law. Great. Okay. Now, when we talk about rules, we're not going, if you spot that it's about agreements, whether they've made an agreement, a valid and binding contract, and you you know that you need to talk about that. It's not, here's everything I know about how a contract is concluded. Here's everything I know about how an agreement is reached between the parties at law. It's about going back to those issues and talking about the legal principles that are directly relevant to the issues that you've spotted. Okay, so don't write a textbook about that area of the law. Stick to the issues that you have identified. Okay, and then we've got A. What does that stand for?
Analysis, application.
Yeah,
Absolutely.
application of the law.
Yeah, so in a problem question, it's application. Maybe some analysis will come in there as well, because it could be that the law is ambiguous, at which point you need to interpret it. Now, it can be ambiguous because the English language is a wonderful language, because we've got thesauruses that are this thick that give us hundreds of different ways of saying the same thing. But what that also means is it gives rise to ambiguity. And so it may be that there are two different ways of interpreting the words that have been used in the statute. So at that point, you will need to engage in an analysis of what the most likely interpretation will be. Now, when I say what the most likely interpretation will be, I mean, what is the court likely to do? So it's not what you hope will happen for your client. It's not what you will argue for your client. It's what the court is likely to do. And sometimes that actually means giving your client bad news, right? Because we have to tell the client what's likely to happen in our professional opinion, so that they can then decide what their next step is. They may go, whoa, that's too risky for me. I can't afford to litigate anymore, for example. Okay. And you might say, well, let's try and settle or mediate. Yep.
So would you get that from case law and some precedents and things like that, or?
So in relation to what? So
well,
working out whether when we're in.
Yeah, you're advising your client, and you're like, like it's a jail sentence for his offence.
Yeah. Okay. So, okay, take a jail sentence, then, a sentence, then yes, you'd use precedents, because you would look at how the courts are generally sentencing that particular individual for a crime committed in those kinds of circumstances. So, there's a big difference between trafficking, $1 million worth of cocaine and street selling $50 worth of cocaine, right? So that might produce a different sentence. So you would look at cases for that. But if we were looking at a statute that was ambiguous, then we would look to see if that particular word or phrase that was problematic had been interpreted already by the courts. If it hadn't, and there are two or more alternative interpretations open, then you would start to use convention in terms of statutory interpretation. So you'd be looking at the context, you would be looking at the purpose, and you would be using that to guide what the most likely interpretation is. But let me tell you that this is not a perfect process with a perfect answer, because that's why people go to court. That's why people end up litigating, because the lawyers take different positions. The lawyers adopt different interpretations of the law and then argue about which one is correct. Most clients can't afford to litigate just for the hell of it. So then they're usually litigating because they think they've got a relatively good case, at which point that means that they've had advice that tells them that the law supports them. So, there's not a solution to that interpretation issue necessarily. All we can do is exercise professional judgment that's based on sound reasoning to identify what we think the most likely interpretation is. Now, there could also be problems with case law rather than statutes as well. It may be that you've got no appellate decision. Okay, so we'll learn about the doctrine of precedent. So the High Court being the highest court, if you've got a High Court case, that's great, because hopefully that provides clarity. But quite often in the common law, we can end up with differences across jurisdictions. And so you end up with different interpretations of the law in different jurisdictions, and you might have to tackle that as part of your analysis. So yes, there is analysis there, but in a problem question, one of them, the thing that the A really stands for most above anything else is application. And what that means is application of the law that you have just discussed, that is directed to those issues that you identified. So the application of the law to the factual scenario. What this means is that you are basically telling your client how the law impacts them. What does it mean for their case? So so for example, if you're looking at whether or not the contract has been concluded with our postbox scenario, okay? So we've got party B signs the contract, pops it in the post. If the postal rule says that the contract is concluded at the moment that it goes into the postal box, then applying that to the facts of the situation, the contract is concluded on the day that it was posted. What that means is that the contract has formed at that point, and if the other party has now gone and sold the goods to someone else, they're in breach. So do you see how we've taken the rule there and we've said what it means for the parties involved? Okay, so application. Now, it's the most important part of the process for your client, absolutely, okay? Because that's what they're paying you for. They could probably Google the law, although they wouldn't necessarily get what they need. Your job, obviously, is to identify the material facts. And believe me, when clients come into your office, they tell you lots of immaterial things. And it's your job to work out what the important facts are. And then you would explain the law very briefly in terms that they can understand. And I know the temptation is to impress them with lots of legal jargon, but they just sit there and look at you blankly. So there's no point in doing that. So you explain the law in a basic manner that they can understand, but the bit that matters most to them is the advice. So at that stage, when you apply it to the facts, that's where they're really interested. That's what they're paying you for. And that's the bit that really distinguishes the lawyers from everyone else, because that's where we're exercising our judgment. That's where we're showing our logical, reasoned approach. And it's where we are showing our legal reasoning. Now, at this stage, I'm kind of giving you obviously just straightforward examples, but as you get further in your degree, you'll be doing your IRAC for several issues. So we don't just do 4 paragraphs, and 1 is I, 2 is R, 3 is A. You do the IRAC process for each issue you identify. So let's say that we've got that whether or not they've concluded a contract is issue 1. Issue 2 is whether there is a breach, and issue 3 is damages. So you would have your IRAC process for 1, and you would complete that process before you move on to looking at breach, complete that process before moving on to looking at damages. When you've got several issues, it's also important to identify what order you should present them in. Okay, because you need to make sure that you're adopting a logical approach to the question. So for example, it would be illogical to talk about damages before you've talked about whether or not there is a contract and whether or not there's been a breach, because you only get damages if there's been a breach of a valid and binding contract. And it would be illogical to talk about breach first if your first issue is whether or not there's a contract at all, because if there's no contract, there's no breach. Does that make sense? So you really need to plan before you write is another tip in relation to that. Okay, and then we've got C. So what does C stand for?
Conclusion.
Yeah, absolutely, conclusion. So note that, as I've already said, there's not usually a definite answer, and that means that we allow for variation in our marking. You won't necessarily reach the same conclusion as the student next to you. We're actually marking you on your reasoning process rather than whether or not you think the answer is A or B. Okay, so it's your conclusion summarizes the position in relation to your I, R, and A. You need to reach a conclusion though, so if there are two alternative interpretations of the law open, you need to say which one is the most likely of the two and why. Okay, so at this point you're exercising your judgment. It will be based on experience, legal reasoning, if it's a statute purposive approach or previous cases. If it's precedent, it might be based on an analysis of the cases and which one you think is either closer in facts or the principle suits that particular scenario, whatever it happens to be, okay? But you need to explain that as part of your bringing it all together, which option you think is the most likely and why. Now, what I would like to do now, sorry, we've got just a question and then I will carry on, hang on. Which is best to state first, your final position or the other alternative? Good question. That's really a matter of personal preference, but I would flag both alternatives first and then say which one is preferred and why, because then you've fully advised your client then, and they can make a really informed decision about what they want to do. So you've said, well, this could be interpreted this way, and this is what happens if we interpret it that way. And it could also be interpreted another way, and this is what happens if that happens. I think this one's more likely and why. Okay. Also, it's important to give your client practical advice. Now, you don't need to do that for this problem question, okay? But in reality, when you're a lawyer, clients want practical advice. So they want to know about things like, can we make proposals to settle, or could we go to mediation? Could we get discovery of documents? They want to know all those kinds of practical components. But for your problem questions, stick to answering the question. So that means identifying your issues and working through them like we've just discussed. But that also means at the end, providing overall advice. So if you've got those three issues we talked about earlier, so is there a contract? Has it been breached? What damages might be available? Once you've worked through all of those, you need a conclusion at the end, okay, that brings together all three into a summary. All right, so what I'd like to do now is I've got a question, a problem question, a little scenario for you to do. It's along the lines of the causation issue that Luke used in the lectures as an illustration of the IRAC process. So what I would like you to do is read what I'm about to share with you. I'd like you to think about what's potentially significant. So what are the material facts and what's not material? What issues arise in this question? And then think about how we might then tackle the R, A, and C aspect. So let me just share that with you now. 1 second. Okay, can you all see that? There we go. Let me put it as a full slideshow. Oops, that's not good. Technical issues.
No, we can see that. Oh.
Yeah, I'm trying to get it as full view, but it won't let me do it. So
it displays when it pops up, and it should rotate it.
Okay, maybe I'll just leave it like that because it's just not playing ball. Okay, so as you can see, we've got Chris, who is a council construction worker who has dug a hole in the road to fix a leaking water pipe. When he realizes he's about to miss his favorite TV program, he erects a warning sign and a cone near the hole and then dashes home. Now, Alfred is a resident who lives on the street, and he subsequently removes the sign because he wants to wear it as with the cone at a fancy dress party later that evening. Sounds like had too many beers. Danny was driving his scooter along the road when he crashed into the hole in the road. Now, Jennifer observed this and called 000 for an ambulance, but there was a 60-minute delay before the ambulance arrived. And this was because Ellen, who's the on-duty paramedic, was busy talking on her mobile phone helping her daughter with her homework. So she didn't hear dispatch trying to contact her. Danny died from his injuries on his way to hospital in the ambulance. Now, this all sounds very far-fetched, but believe me, there are cases that you will do in tort law and possibly also criminal law where, you know, on the when they're getting the victim who's been in a fight or had an accident at work or whatever, when they're getting them out of the back of the ambulance, they drop them on the floor, on their head, and, you know, all of those kind of things. So really crazy factual scenarios do actually arise in real life. Okay, so I'm just going to give you a couple of minutes to think about what the material facts are and what the issues, what the legal issues might be in respect of that question. Now, I'm happy to answer questions in the chat while you guys look at that if you would like. Oh, good question, Kelly. What perspective are we looking at it from, criminal or civil? In this instance, let's say civil, but interestingly, the legal issue is the same in both. Okay, so what I need to leave the screen up so that you guys can carry on reading it. But what in that first paragraph, what are the material facts, do you think?
Well, whether Chris is negligent in his duty of care.
Okay, yep, so that's not the facts though, that's a legal issue. You're absolutely right. It's whether or not Chris ultimately is responsible for the injury to Danny, right? But that's a legal issue. So that comes from taking the law on negligence and applying it to the facts to conclude whether or not someone is negligent.
Okay, sorry.
No, don't be sorry. Don't be sorry. That's the tricky thing about law, is that when we decide something like X is guilty of an offence, or there has been a breach of contract, we're actually doing all of the legal and factual together to reach that conclusion. And it's something that is difficult to understand, that we then have to work backwards and separate them and work out what the facts are and what the legal issues are. Okay, so Chris has dug a hole, leaves it unattended with just a sign and a cone, right? That would be material. Why is that material?
It was the act that started it.
Yeah, okay. So that causes Danny to crash his scooter, yeah? So it's falling down the hole. It's, you know, he didn't see the hole, falls down it and has an accident. But there's also other facts in there that are relevant too. So what about Alfred?
Alfred removed the sign and cone to wear as a costume at a party that he had to go to.
Okay, so Alfred's obviously having a great time, removes the sign and the cone. Now, in this instance, it doesn't matter why he's removed it. That's not material, okay? It doesn't affect Danny's injury or who's responsible for it. But what is important is that he's removed the sign and the cone. Now, can anyone have a guess at why that might be important here?
He removed the caution.
Yep, okay. So why might that be important as a material fact though?
Well, it leads to the death of Danny, doesn't it?
Yeah, well, it may affect his ability to see the hole before he drives down it, right? I mean, we'll never know, will we, whether or not he would have seen it had the sign been there, but anyway. So in this instance, there's two potential problems there. It's that Alfred's act may have broken the chain of causation for Chris, okay? So Chris is initially responsible, and then there's this new act which is called a novus actus interveniens, which is an act that's new that breaks the chain of causation. It could be possibly that, in which case Chris can no longer be deemed responsible because of this new act which breaks the chain of causation. Alternatively, maybe Alfred could be liable himself.
Yeah.
Okay, so two issues there that pop out of that material fact. And then what is subsequently in that paragraph relevant? Well, Danny crashes his scooter and falls into the hole. Then paragraph 2, what's material in paragraph 2?
So, could you charge, the guy Alfred with theft as well? Would that be, theft of council property?
Yeah, sure. I mean, it's possibly a criminal offence there. There's a range of criminal offences that can be committed if you're drunk and making a nuisance of yourself, for example. But
can I ask a question just in regards to when you were talking about? Sorry, this is back in the first paragraph.
Yep.
The comment about it in the thing in our study guide talks about including missing facts or assumptions and that sort of thing.
Yep.
Could you address, so Chris has put out his sign or whatever, when you're talking about chain of causation, what if he hadn't put, hadn't secured the sign properly and that's why old mate could steal it so easily? Like, do you list in there, the details around what may not just break that chain of causation?
Not usually, no. So you're kind of hypothesizing there.
Okay, so
in the same way that I was said, well, maybe Danny wouldn't have seen the sign anyway. Do you know what I mean? So not really in that sense, but let me give you an example of when you would have to explore possible implied facts. So let's say that there's a car collision, and when we go to open the door of the driver who's trapped inside the car, you open the door and their mobile phone is on their knee. Okay, so you might make an inference that they were on their mobile phone at the time of the accident. Does that make sense? So we're not told in the facts, we're not told that the driver was seen with the phone at their ear. So we cannot categorically say that they were on their phone, right? But because they've got their mobile phone on their knee, we can draw an inference that perhaps they were on their phone at the time of the crash, and that's how it came to land on their knee after the accident. Does that make sense?
Yes.
Okay.
Yeah, thank you.
Yeah, so, but you can see how you're told that the mobile phone is on the knee, so there's a pointer there to discuss it. I've not just randomly thought that out, whereas in the scenario you just posted, there's no hint of that prior to that, so you're then adding and hypothesizing about the question. It's tricky, and I totally appreciate that, but you'll get used to kind of working out when you need to imply something and address something and when you don't. Okay, now other important facts in paragraph 2. What would you say? Sorry.
The ambulance driver didn't come on time, so...
Yeah, absolutely. So Jennifer obviously calls 000. I mean, that's an important part of the story, but is it pertinent to any of the legal issues that are going to arise? Probably not.
Really.
Okay. The issue is the 60-minute delay and the fact that Ellen did not hear dispatch trying to call her. It doesn't really matter why Ellen is busy talking on her mobile phone. If she's taking another call, if she's talking to an elderly woman who's fallen down the stairs, then that might be important, because what you're saying is that she was unable to attend because she was working on someone else, and that's a different scenario. But here, it's just the fact that it's a private call, right? And she's not paying attention to her job because she's taking that private call. Okay, and then obviously it's important to note that Danny has died rather than being injured, because the consequences are different in, say, criminal law with death compared to personal injury. Same with civil law, you know, the damages that are available and the cause of action varies depending on what the consequences are. Now, what we need to do is think about, I'm just going to come back to you because I don't want you to stare at the screen the whole time. I'll just stop sharing for a second. So what kind of issues do you think arise out of those facts that we've identified as being pertinent?
Well, Chris dug a hole and he left it alone without supervision. That's one fact we know.
Yep.
Alfred removed the signs at the hole.
Yep.
So you said like the chain of causation.
Yep.
And Ellen was, well, it's not a fact, but Ellen was on a private call.
So Ellen is also a potential break in the chain of causation as well, isn't she? Because it could be, I'm not saying that it is, but it's something that you need to explore and discuss. It could be that Ellen's delay meant that he died when he could have lived. Does that make sense? So you need to look at whether or not Alfred breaks the chain of causation in relation to Chris's responsibility, and also Ellen as well. Okay, so that's Chris's responsibility. So you've got to talk about Chris and what duty of care he owes and all of those kind of things. Then you have to look at the facts are telling you that there's a chain of causation issue in relation to Alfred and a chain of causation issue in relation to Ellen. Then you can turn your attention to Alfred and say, can we hold him responsible?
Yes.
For the death? Okay, and then you would have to look at whether Ellen breaks the chain of causation for him. So that's why chronology is really important. You've got to make sure you get your facts in the right order, okay? Because Ellen comes after Alfred. Okay, so on that issue, we've got Alfred. Let's say Alfred is responsible. The only one that comes after him is Ellen. Ellen might break the chain of causation for Alfred. And then, of course, we've got to look at Ellen and say, is she liable because she owes a duty of care to her patients, etc. Okay, now there's no chain of causation issue. You would just be discussing her liability there. Okay, now that's where a question leaves it open. So just discuss all the issues that arise in this question. You'd have to pick them through like that. You'd look at all the potential people who are potentially liable, and then look at the illegal issues for each of them. Sometimes a question is more directive than that, and it might just say, discuss the liability of Chris. In which case you would only look at Chris and then the chain of causation issues as well for Chris, okay? But in this instance, because it's open, you'd have to look at all three. So what I would like to do is talk about how we would now talk about the law, focusing on Chris only, just because of time. But how would we talk about the law in relation to Chris and how we would apply it? So the rule would be, and Luke talked about this in the lecture, would be something like, according to the case of Royal and the Crown, a defendant's acts may be deemed to have caused the death of the victim if they were an operating and substantial cause of the death. So in that instance, operating and substantial cause is the test, okay? So even though, what you're really asking yourself is, even though Alfred took away the sign, even though Ellen didn't turn up for 60 minutes, is Chris's conduct still an operating and substantial cause of the death?
Yes.
Okay, so that's something that you'd need to explore. So we've said what the law is, according to the case of Royal, and then you'd then have to apply that to the facts and say, so Carlo, why you think that he's still an operating and substantial cause of the death? You could also discuss the case of Cheshire, which says that the degree of negligence in any intervening act, so any chain of causation act, is not relevant to whether or not it breaks the chain of causation. So whether someone is negligent or has complete disregard for someone else is not relevant. That degree of difference is not relevant when assessing whether or not the chain of causation is broken. So again, you could explain that and say, so Ellen, the fact that Ellen is negligent is really the only test of that. So Ellen is negligent. Is Chris still responsible because Chris contributed an operative and substantial cause of the death? Okay, now,
I have.
Yep.
Sorry, I have a question. What about Danny? Is Danny really have a responsibility?
Danny. Who's Danny? Danny's the one who's died, yeah.
Yeah.
Okay. Well, Danny's not going to sue himself, so...
Yeah, of course, because he died, but what I meant was, because he's supposed to watch where he go, like he's supposed to look at the the board display.
So in tort law, there's a thing known as contributory negligence. So what that means is that, so for example, if there's a car collision that's the defendant's fault, and let's say I'm the plaintiff, I'm driving, okay, and there's a car collision and the defendant causes the collision, but then the defendant alleges that I wasn't looking properly and someone else would have stopped in time, then they would say that I'm contributory negligent. Does that make sense? Or take, for example, a situation where you're driving down the road and someone runs out in front of you and you hit them, okay, and let's say you break their legs, then in that instance they would claim against you for damages for obviously knocking them over, but they might be contributory negligent because they might have run out in the dark wearing black, you know, at night, not looking, not allowing for traffic. So there is that there's an assessment at the damages stage that can occur when there's contributory negligence, absolutely. But in this instance, we're really looking at just whether or not Chris is responsible, not the calculation of damages. Or if it were a criminal matter, it would be whether or not Chris has committed a criminal offence, okay? So on that basis, it might be relevant at sentencing that Danny partly brought about this on himself, okay? But at the same time, Chris might still be responsible. Does that make sense? Okay. So what I was trying to say was that we need to take the rule, which is the case of Royale, says substantial and operative cause of death. It's no good to just state that in your answer with the case citation. It has to be applied to the facts to mean something for the client. This means that, you know, in this instance, had Chris have finished the work or put appropriate safety measures in place, then Danny would not have crashed the car. Okay, Danny would have seen the clear signage that is normally used, or the road would have been fixed, or whatever it happens to be. So it's important to make sure that you say how the law relates to the facts and how it applies, and then obviously reach your conclusion on that. So just out of interest, I might conduct a poll to see where you guys are at. So let me just try and create one now. It's not going to let me because it's having a complete headache today. It's completely... No, it's not going to let me do it. Okay, so maybe we can do it by a show of hands. So I think you can raise a hand with your reactions at the bottom. So raise a hand if you think that Chris is responsible. There's no right or wrong answer. I'm just curious to find out if Chris is responsible for the death of Danny. I do that now. So we got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Well, about half of you. So it looks like it's going to be 50-50. Okay, that's interesting. So I think this is the problem with law, right? There's a grey zone here.
Yeah.
But that's why people end up in court. I mean, most people try and avoid court at all costs because it's so expensive. They'd much rather go through an ADR process and mediate or negotiate to settle. But we end up in this situation where the court has to determine the dispute for the parties. It has to give an answer as to whether or not Chris is responsible. Does that make sense? And of course, if you move into the criminal setting, then the state will proceed with the prosecution, and it's the court that determines whether or not Chris is guilty. Okay. All right. So let's have a look at the other questions. So question 1 now. So there's a series of statements that or assertions that have been made, and the task is for you guys to identify what issues arise with, and by issues I mean problems, what problems arise with those statements. So taking statement 1, violent video games should be censored or banned. There is evidence that many people who commit violent acts also play violent video games. So what do you guys think about that statement?
It's a generalization.
Very good.
There's no causation to say that violent video games produce violent people. You can do a search on Psychlite and find out, but there's no studies to show that.
Yeah, absolutely. So there's a couple of things there. Firstly, it's a generalization. Note that there may be a range of reasons why someone commits a violent offense. So you're just taking one particular aspect and saying that it is on its own causative. Okay, you're saying this is the reason. And of course, as I say, there may be a series of reasons. So it's too general anyway, but then it's also not backed by any sources in support. It says that, what does it say? There is evidence. So it makes this assertion that there's evidence, but it doesn't present us with any, does it? And then when you get that evidence, we don't just stop there and go, oh, thanks for the evidence, I believe you now. You have to evaluate the evidence. So is it, a statement from a political leader who's trying to adopt a particular angle? Because that is different to, say, a peer-reviewed journal, can't speak today, a peer-reviewed journal by a psychiatrist or a psychologist who has done a study who says, actually, this is the case. Those two things are completely different, right? So ScoMo versus a psychiatrist who's conducted a study and is an expert in the field, right? Okay, so we need to evaluate the evidence as well. What is its reliability? So in its current form, I would say that this is faulty reasoning. No evidence presented. Evidence would then have to be assessed and evaluated for its reliability. At the moment, it's just a generalized statement. Very good. Okay, what about number 2? So judging by the number of articles about unprovoked attacks in the CBD in recent months, the city is becoming increasingly unsafe at night. What are your thoughts about that?
Another generalization.
Yeah, it sounds like something that might appear in a newspaper to me.
It's only talking about the number of articles, not the actual number of attacks. There could be no correlation between them.
Absolutely. So it's not data-based. Maybe it's based on newspaper reports, newspaper articles, or, we don't know, but it's not. Here are the police statistics on the number of attacks in the CBD and the percentage of those that are unprovoked, right? It's talking about articles. Okay, what else?
Well, you don't know what's causing the attacks. Is it drug, alcohol? What are they referring to?
Yeah. So again, we're going back to that reliability of the evidence as well. So once you get the evidence, what are these articles? You need to evaluate them. Where did they come from? So who's written them? Have they got an agenda? Is it a journalist? Is it based on statistics? So the origin, quality, and reliability of that evidence is important when you're evaluating that statement. So note that we, again, would need citations so that we can check the reliability of these statements. Now, these kinds of statements, okay, so this one and the one above, you might actually be presented with something similar as a theoretical essay question. So we just did a problem-based question looking at Danny and Chris, right? That was a problem question. You get a factual matrix, and you have to advise one or more of the parties that appear in the facts. A theoretical essay question is more about policy, a discussion about the law, the current state of the law, how it's advancing and developing, whether reform is necessary. So it's much more abstract. It's not necessarily based on facts. So you might get a question like this and then have to assess that question and address the question. So this is all good training for those kinds of assignments that you might need to complete. Now, what else did I need to say about that? I'm just looking, hang on. So we can't, in this instance, when you're evaluating a theoretical essay question, if someone gives you data, it's no, or gives you a source, it's no good to just accept the source. You need to evaluate the source as well. Next question. It is acceptable to use torture to extract information from a suspected terrorist, since any pain suffered by the suspect is outweighed by the good resulting from the saving of many lives.
Seems unethical.
Sorry, go ahead.
I was just saying it seems unethical.
Yeah, it raises issues of ethics, absolutely does. So, you know, as lawyers, we believe in the rule of law. So we believe that governments can't behave in this particular manner towards their subjects. But and it raises issue of ethics of one life being worth more or less than someone else's as well. So there are moral issues there within that question, which might make some people feel quite uncomfortable. So those two issues are definitely there. But ignoring that just for a second, how it makes us feel, what's the problem with the logic in this question?
The information that you might get out of a person that you're torturing, or however you want to phrase it, becomes untrustworthy or whatever due to coercion.
Unreliable, absolutely, it does. So there's a range. In previous generations, police officers used to, and it still happens now, okay, I'm not saying that it doesn't, but in previous generations it was quite usual to be very rough with defendants and then extract confessions from them. And there were a number of convictions which were unsafe as a result of that. And there have been a number of people who have gone to prison based on a confession that has later been proved to have not been true. Because when you're being beaten or tortured or whatever, sometimes you'll just say whatever they want to hear to make the action stop. Okay, so the reliability of the evidence is questionable. What else is wrong with that particular statement?
It is again not proven fact. It's no authority for that.
Yeah, absolutely. So there's nothing to suggest that that is actually a true position. But also thinking about the background around this, firstly, ignoring the rule of law, many countries still state that it is illegal to torture people who are detained. So there's conflict with the law in that instance as well.
Are you making one person judge during execution, or once? Are you not separating the powers that should be there, all rules of law?
Absolutely. So we would normally have the police would conduct an investigation, and then the court process would determine the guilt of the defendant. In this instance, I mean, the defendant's not necessarily found guilty, but they receive a sentence, they receive a punishment, right? So in that setting, they're still going through this sort of extrajudicial experience. So what we're seeing there is a really It's a broad statement that isn't supported by evidence. It also lacks a logical foundation because, as we know, that evidence is likely to be unreliable. Anyone else have any other comments about that?
Someone should tell Mr. Obama about that.
I think there's quite a few more leaders that might be subject to criticism. Okay, so Teresa says, in terms of taking data into consideration, how recent should the data be? The last couple of years or 10 plus years, not relevant. Depends on the context. The law changes relatively rapidly in some areas. And so if you've got journal articles that are talking about the law in that area, they're going to be really out of date if they're 10 years old and the law is changing really quickly. And then you get some areas of the law that move really slowly and you wouldn't necessarily have that problem. When you're talking about proving things with statistics, such as there's been a 20% increase in crime in Cairns, then you'd need recent statistics to show that, okay? Unless you were doing a historical analysis where you were saying, you know, over the last decade, there has been this transition in statistics. So it depends on what evidence you are, what evidence you need and what you need it for as to how you assess or evaluate it. Okay, then one final statement, a rational, so I was just going to say with the torture thing, what you would want to do is evaluate. You may adopt a particular position on that, and that would be absolutely fine. But what you would need to do is critique the other side's arguments and then advance the alternative argument as well. Okay, you can't just put your opinion out there and say, okay, I'm done. That's why we go through that evaluation of their position to show its weaknesses, and that just reinforces your own argument. Okay, finally, a rational legal argument will always defeat an argument based on faulty reasoning. So what's your thoughts about that?
It should do, but unfortunately in courts with the jury, you have lots of emotions.
That's true. Oh, and it's not just juries. I mean, parties themselves can get caught up in the emotion rather than what makes sense in their situation.
Yeah.
I think one of the things that you would need to do with this kind of question is actually break down what it's really saying. I mean, what is a rational legal argument? You probably first need to address that and define it. And then you would have to identify what faulty reasoning is. So perhaps outline the different ways in which reasoning may be faulty. And then that would then give you a basis for then establishing whether or not that statement is correct. So in terms of logic, you know, what makes up a logical argument? What makes up a legally reasoned argument? And you need to explore that. And then you would be able to probably say, it should be true. We hope that it's true, but it's not always true. Okay, so that brings us to the end of the questions for this week. Do any of you have any questions?
Sorry, could you go through that step again with the different IRAC? You were saying, I kind of got it, but I kind of didn't understand. So if you have many issues, like you said, and you would go through and do an IRAC on each issue.
Yeah, absolutely. So take my...
Yeah, sorry, and then your conclusion right at the end, kind of thing.
So you'd still have your little conclusion about that issue for each of the issues. Yeah. Okay, but then because it's an essay and because you need to provide overall advice, you then have a paragraph at the end that summarizes and provides advice to the client. Okay, yeah. So you always have, when you're doing your IRAC process for each issue, you'd always have at least one line in your paragraph that's dedicated to the conclusion on that issue before moving on to the next, always.
So that'll be in one paragraph, that IRAC, yeah.
Yeah, it doesn't necessarily, it depends on how big the issue is. So,
Yeah.
like, if there's 5 cases you need to discuss, you wouldn't necessarily have that all in one paragraph because it'd be quite a lot to absorb.
Yes.
So in that instance, you might want to use headings, right? So you'd start off with the first issue is whether or not whether they've concluded a contract. So you might start off with conclusion of the contract as the heading. Then you could have a series of paragraphs dealing with that. And then the next heading would be, has there been a breach of contract? So that you're symbolizing to the reader that you've moved on to a new legal issue through the use of the heading.
Yeah.
And we love headings in law, okay? Don't be frightened to use them. I know that in some humanities subjects, people don't tend to use them, but imagine this. Imagine you're a judge and you've been provided with an outline of argument. Now, an outline of argument is a document that counsel provides in advance of the hearing. So, and it provides a summary of the arguments that counsel will make in the hearing. And it also obviously puts the judge and the opponent on notice about what cases and statutes will be discussed so that everyone can look them up and have that kind of working knowledge. Imagine that you're a judge though, and you've got a 20-page outline of argument and you've only got about an hour to work through the case before the hearing. You're going to want to look at, you're going to want to scan read it, okay? And you're going to want to find what the real issues for you as the judge are in the case. So headings are a great way of helping the judge find what they need when they're time poor and they're preparing your case. It's really directing them to the content that they want to find. Okay, and so headings are great. We use them all the time in law.
Thank you.
Okay, so Ellie, everyone is human, they have emotions, and also they have their own personal views and beliefs that will often play into whether or not they can accept your point of view. That's very true. And that's the difficulty of being the lawyer, is that you're dealing with a client's real life, and it's going to impact them in a meaningful way. So they don't always receive your advice very well. And they won't necessarily even accept what you're saying sometimes. We are more likely to accept a point of view that aligns with our own ethos and beliefs, and so sometimes don't acknowledge that. There is an element of bias in things, in processing information, absolutely. And we try to be mindful of that in law. We're not always perfect at it, but we try and be mindful of that and try and break down the issues and adopt an objective and neutral position to each issue. Kelly, is the assignment question, what was the date of the accident? I don't know what you mean there, Kelly. So if you're talking about the problem question, in the assignment, what was the date of the accident? I don't know. I will have to check that for you and let you know. I'll put it in an announcement on the forums. I don't think that it's actually important because you've been provided with the resources that you need. So you would just be advising on the law as it's been provided. Okay, in real life, you need to know when the accident occurred, because there might be changes to the statute that have been made over time. So you would need to advise the client on the law that was in force, that was in operation on the day of the incident, which would be the accident. And of course, that legislation, you might need a previous or prior version of the legislation, because that was the provisions that were in operation at that time. But we've given you what you need, so that timing issue doesn't really arise. Yeah, just use what you've been provided. So the aim of that task is not to get you to research 1,000 cases on health and safety or whatever. It's actually to get you to work through the materials you've been provided in a logical way to answer the issues that have been addressed. Okay, so the questions that we have posed. Okay. All right. Any other questions?
No.
No? Okay, well, it's lovely to see you all. And I look forward to seeing you next week. If you've got any questions, please feel free to post them on the forums or in Teams. We'll be doing the surgery again on Thursdays at lunchtime, so feel free to drop in if you have any other questions. Okay, thank you everybody. Have a great week.
Thank you.
Bye.
Bye. Bye, everybody.